अपने आप को म्यूट करो।
हाँ मैडम।
I welcome you all in the today's session, which is the day of 5th of our symposium. And the symposium theme is the changing concept of liability and its concepts. I give the credit for the title that has been invented by my colleague, Ms. Kiran Chauhan. She is there on the screen. Kiran Chauhan, Dr. Ms. Kiran Chauhan, please turn on your camera because it looks very nice. Whether you can be in any uniform, we don't mind, but you are a citizen of India, so be confident. Okay, धरती अपनी है, किसका डर है रे? है ना?
सही है
Every
जी।
morning I was listening to Lagan song, and you should not be afraid in whatever dress you are, but you should be a citizen, a civic citizen with all liability to respond to certain organized event that we are holding for our institution as a host. So I welcome you, Ms. Kiran Chauhan, for being with us today once again. Dr. Shilpa Seth, good evening to you. Turn on your camera so that we can see you. Now, I would like to inform you that our host institution, Bhupal Nobles University, is celebrating this event in the aegis of Bhopal Noble Sansthan, that is celebrating its 100 years of its existence, of its foundation, of its establishment. It got established in 1923 and it's finishing with its 100 years in 2023. So this current year is the year of celebrating a lot of events in hybrid mode, offline mode. So this is all we are doing as an inspiration behind this 100 years. And this Bhopal Noble Sansthan has been patronized by the chief founder or chief patronizer, Maharana Sahib Bhupal Singh Ji, late Maharana Bhupal Singh Ji of Mewar. And the Maharana was the pioneer of education in Udaipur. In those times, he started this institution as a small primary level, and then it has till date in 100 years gone to such an extent in that it has its branches in suburbs of Udaipur or and outside other Udaipur district. And our co-host, the co-host is GAIS Institute, which is working in the label of International Institute for Advanced Legal Sciences. That co-host name is Professor Salvatore Tolone Azzariti. He is the professor of civil law from the University of Oxford, as well as from the University of Buenos Aires in Argentina. So with an integrated approach and collaboration, we have thought to bring out certain kind of lessons so that these lessons that we have been having on during all this 7 day symposium would be, of course, added into the website of GAIS Institute's group of members who are establishing their institute, but also in the digital university perspective that BNU would be looking forward to it in the national education policy that would be executed in 2023, most likely. So this whole 7 days symposium, indeed a kind of a plan into the perspective that is going to be finished or linked with the other goals of our education policy. Now, we have got today 3 speakers. First, we can see on screen Rakesh Pariyani ji. He has to actually introduce himself, so I'll take a pause here because he did not provided me with his bio data. So, Rakesh Pariyani ji, you have to introduce yourself first.
Yes, ma'am, sure. First of all, good evening, everybody here. Myself, Dr. Rakesh Pariyani, and I am from Udaipur, Rajasthan only. And at present, I am posted as Judicial Magistrate at Vadodra district, and I am working here since 2012. The whole education is from Udaipur, Rajasthan, from Mohanlal Sukhadia University, and I have completed my doctorate in cybercrime from MLSU University in 2010. That's about me. So I will talk today on civil liabilities. Uh, then my session starts.
One more question to you, because you are an alumni of Mohanlal Sukhadia University. So, it's a very creditable thought, you may say, that I'm passing on to you. But because the whole Mohanlal Sukhadia University Department of Law has been skipping this symposium, and you are, as an alumni, representing that university. So I congratulate you with kind of spirit. And I think you are referred to me by Dr. Kala Munet.
Hello.
She's the
Yes,
chair of today's session. I
yes.
really humbly, you may say, greet her for, and even thank her for providing us to you with you, so that you can deliver your talk. Another
My pleasure.
question, one more little question to you. You have written in your some small bio note that some kind of acronym or abbreviation, JMFC. What does it stand for?
It is Judicial Magistrate First Class. So I am posted
Okay.
as Judicial Magistrate First Class at present in Vadodra district. That's what I have mentioned.
All right. So let's, shall we continue with your now discourse?
Yes, ma'am. Yes.
Thank you.
First of all, I would like to congratulate BN Sansthan, who was who is established in year 2000 in 1923 and is going to complete 100 years in 2023. So it is a very proud moment for me also, because being a Udaipur candidate, being a student from Udaipur, it is also a proud moment for me also. I have also passed and did many courses from BN College also. So I was also a part of BN College in year 2000, I think 5 or 6. So it is also a proud moment for me. Uh, Today, I would like to share some things on the concept of negligence, and which is a concept of tort. As we all know that tort is not a codified law in India. As we see, it is internationally codified. In many of the countries, it is a codified law, but not in India. So the courts of law in India treat all the concept of tort on uh, the concept of justice, equity, and good conscience. So there are many cases we see today in our today's era. Uh, the concept, or the liabilities which are based on the maxims and on the stories, on the factual aspects, which are codified internationally on the concept of tort. But since it is not codified in our country, we deal them on the basis of justice, equity, and good conscience. The main topic which I would like to share today is negligence. Uh, Negligence is a most wider concept in tort, but I would like to precise myself on this topic, on the concept of negligence, with a special reference to accidental case. The only reason why I chose this topic is that today we all know that the life is so busy. We are so busy throughout our day that we start our vehicle in the morning, and we move here and there, and we end our journey of the whole day with our vehicle, directly or indirectly. I mean to say, in our vehicle or in public transport, or our family members are in some vehicles, etc., etc. And directly or indirectly, intentionally or unintentionally, we commit some mistakes, or we act in such a way that due to our negligence or some others' negligence, accident occurs. The simple definition of negligence, as we all know, is a breach of a contract. It is a breach of contract against our duty. And when our duty of care is breached, another person suffers. And that is and some legal injuries caused to him. That is a negligence. So since we know that we are dealing negligence in when we are dealing negligence in civil side, the person who is coming to the court has only to prove that there was certain form of negligence on defendant side or on other side. That's it. If we compare this civil negligence with criminal negligence, in criminal cases, the person has to prove his fact or his case beyond reasonable doubts. So this is the main thing one should understand between criminal liability and civil liability as far as negligence is concerned, that in criminal cases we have to prove the fact beyond reasonable doubt. I mean to say, the person who committed negligence, we have to prove, or the person who has approached the court has to prove that he has absolutely committed error or he was 100% negligent. There is no suspicion at all. Then and then only, if negligence is proved, he may be penalized, either in the form of fine or imprisonment, whatever the case. But in case of civil negligence, the plaintiff or whoever has approached the court has to prove only fact that the opponent or against whom the case is filed has committed negligence, and the person who has approached the court has got some legal damages. He is eligible or he is liable to take compensation or to receive compensation from the opponent. That is the only thing he has to prove. Now the burden shifts upon the defendant or the another party who has been joined, that he was not so much negligent, or there was contributory negligence, or there was composite negligence, and then only the case is decided accordingly. I will take a simple example, a simple illustration. For example, A is driving a car. He is driving a car. When he is driving a car, he has reached a signal. On signal, we all know that traffic signal is blinking in seconds. Uh, Suppose when A is passing a traffic signal, 5 seconds remaining. 5 seconds are remaining to when signal is going to end. The signal is green. 5, 4, 3, 2, 1, and the orange light is blinking. Still, A thinks that I should pass or I can pass, and he started passing. He started jumping the signal, but all of a sudden he was unable to pass the signal, and before then the red light starts. But we all know, we have all passed the situation. We usually we jump the red light. And in case at this situation he committed an accident, then since we are talking about civil liability, in case of accident, A is 100% liable to pay compensation to the person against whom accident is committed. Now, we are very clear about this fact that uh, since every vehicle is to be insured, or at least third party insurance are 100% compulsory, mandatory in India, many of the vehicles are not insured third party. So in this situation, if A's car or A's vehicle is not insured as third party insurance, or he has not purchased a third party insurance policy, then when motor accident claim case is passed against A by the person to whom accident is occurred, A will be liable to pay the compensation as a whole. In case the insurance is the car is insured with third party insurance, the insurance company will be liable to pay the damages on the part of A to the person uh, who has been accidented. Uh, this is a simple illustration, but I have used the words composite negligence and contributory negligence. So to understand this concept, I would like to add another 2 3 illustrations. Let us suppose a person is traveling in a bus, in a private bus or government bus, whatever the case may be. If the bus commits accident or accident is caused due to the fault of the bus driver, then A has nothing to do. A will get compensated by the insurance company with whom the accident is caused. But here, in let us suppose A is not sitting inside the bus. A is sitting on the roof of the bus, and now accident occurs, and A got injured. Now, what should be done? Since here A has himself committed error on sitting on the roof of the bus, which is not permissible at all as per the rules prevailing in India. So A has here contributed in the negligence. Whatever the case may be, whether the bus driver was not driving his bus properly or according to the rules, or he was driving negligently, but since A was sitting on the roof of the bus, A has also committed, A has also contributed in the negligence. So in this case, when the insurance company, uh, when the case reaches to the court, then court will provide appropriate compensation to A for getting injury. But since he has also contributed in the negligence, then his actual compensation will get reduced as compared to my first illustration. Uh, so these are the concepts of contributory negligence. One more thing that I would like to add. Today, we are getting some new kind of vehicles. We are looking around us some electric vehicles. So the main reason behind choosing this topic was electric vehicles. We all are seeing that electric vehicles are increasing day by day on the roads. I hope when we are traveling today on any road, we see at least a single vehicle, whether it is two wheeler or four wheeler, one electric vehicle we are seeing regularly on a road. It means that the number of electric vehicles are increasing. Now, I would again bifurcate my topic with respect to negligence and considering electric vehicle. That electric vehicle are coming in two categories. First category is heavier electric vehicles, and second category is lighter electric vehicles. First of all, I am talking about only two wheelers. In two wheelers, the lighter electric vehicle is coming without mandatory registration, without requirement of license, and without requirement of insurance. So the main point is, suppose a light electric vehicle on which insurance is not mandatory. A person purchases light electric vehicle whose maximum speed limit is 40. It will not cross its speed, we all know. But for example, a person is driving a lighter electric vehicle and he commits an accident. Let us suppose uh, he is going downside the flyover of Sevastram. He is coming more. The vehicle is running more on the faster speed. Since there is a slope, but obvious the speed will increase up to 40, 50, 60, or maybe till 70. Let us suppose an accident occurs. The, ex- the insurance is not mandated. What would be done? Since the insurance is not mandatory, the person who has got injured or who has got accidented, or maybe any person got such a grievous injury that he has died on the spot or died after a few days of treatment, the only person who is the driver of the vehicle would be liable here. In normal cases, in absence of insurance, the owner of the vehicle is liable. But in the present case, the negligence is not of the owner, the negligence is of the driver. So, according to me, the driver of the vehicle would be liable. Now, the question arises, how much liability arises? how much civil liability arises there. I want to clear my point once again that I am not talking about criminal liability. I am not talking about accidental cases of IPC 279 or 337 or 304, etc. I am simply confining my point to civil liability, taking into the picture concept of negligence and with a specific reference to the electric vehicles, and that too with the vehicle on which insurance registration and license are not mandatory. So in this situation, if an accident occurs, since there are no rules prevailing in our country at present, the driver of the vehicle would be liable. Certain people, uh, when they uh, when they purchase such vehicle, and the showroom owner says that, sir, you need not to purchase any insurance, you need not to have any license, and need not to go for any registration. You may drive freely, but this is not the thing. We know that the Motor Vehicle Act doesn't comes into picture in this case, because the vehicle doesn't comes under the category of motor vehicle. So the Motor Vehicles Act would not cover this accident, or would not cover the this type of accident. The MSEP court also, the tribunal also would not deal with this case, but a civil court definitely a civil court would can deal this case, because there is some sort of negligence on the part of the driver, and that driver has committed error. So the person against whom accident has been caused, accident is occurred, has to prove that there was some sort of negligence, there was certain problem with the driving, or he must have slowed down his vehicle, or whatever the case may be, whatever the facts and circumstances he has to prove. But 100% he would get compensation according to the injuries, according to the facts of the case. Now, my second point, with a specific reference to electric vehicles, and considering my precise topic of negligence and civil liability, we have recently seen that four-wheelers with electric vehicle, or with remote control, with remote control cars, are also coming into the market. All of us have heard the name of Tesla car. Since, as far as my knowledge is concerned, there is no production in our country till today with such a computerized car, driverless car. I want to talk about a driverless car, that is a Tesla. We all know that it is a costly car, it is running in foreign countries. Let us suppose an example. If a car like Tesla or driverless car is running on Indian roads, we all know that, we all have seen in YouTube's or when many videos, that the driver is not required in this car. Means there is a GPS system. We would set the position and navigation. According to the navigation, and on the basis of sensors, the car would reach its position without any accident. But I have heard that, I got I got the news that I have seen in a newspaper, that Tesla car also got accident. Also, it has also committed an accident. My point is, I would like to again come on my point. For example, in India, if a Tesla car is running on a road, and and due to failure of its sensor, or due to error of another person, or another driver, if such car got accidented on Indian road, since there is no driver, the driver has no control over the car. My question would be, who would be liable due to accident committed by such driverless car? I am again talking about civil liability, only civil liability. Now, two points may arise. First point, the car is insured. According to Indian laws, third-party insurance is mandatory. Let us suppose the Tesla car is also insured. Third-party liability is on record. So in this situation, simple answer, the insurance company would be liable. He would pay the compensation. We would switch over to second point. The car is not insured, or the insurance has expired. Then what? Then who would be liable? Who who would be the person who has to bear this civil liability in such a driverless car accidental condition? Since there is no control of any person, not a single, not no no any not neither the driver nor the person who is sitting in the car who has to reach somewhere has control on this car, then who would be liable? Whose civil liability would come into it? Since nothing is fixed in Indian perspective at the present moment, so it is difficult to answer this question. But again, I would like to say that the owner of the car has to bear the expenses in this situation, not the driver. It is just my opinion. We have not heard any case in India, and the logic behind my answer is that the Tesla car, which is driverless car, comes with sensors. It runs on navigation system and sensors. So the person who owns such point, who owns such vehicle, or who possess such vehicle, has to uh, satisfy himself that his vehicle is running at the best condition. I mean to say, the sensors are working properly, the GPS and navigation systems are working properly. There would be no chance of accident. It is to be satisfied by the owner himself. If the owner is not satisfied and his car is running on the road, then he has to bear the civil liability in situation where such accident occurs. It is just my opinion, and opinion may vary as the courts of India varies their judgments according to the facts and circumstances of each case. So when any such case comes into the courts of law, the opinion may vary. But since the concept is new, the things are new. We are looking some new things around us. That is the only reason I choose the concept of negligence with a special focus on accidental cases, and that too with a special focus on electric vehicles. With the increasing technology and with the increasing number of electric vehicles and driverless cars. Uh, Another thing I would like to say that in India, majority of us were not uh, insuring our vehicles. This is a common concept, and two wheelers, especially two wheelers, we are not getting third party insurances. Since I particularly dealing with traffic cases on daily basis at present, so that's what I would like to say that insurance is very much essential because many a times we are seeing that some accident occurs, some hit and run case. We are daily seeing that most of the cases are hit and run cases. Accident occurs, the person flees away. The person who has got injured or who has got accidented is being assisted by the roadside passers. He's got hospitalized. He has no information about the vehicle who got accidented. And then when he lodges his FIR for seeking compensation, then only on the basis of information gathered by passers-by or on a just guess basis, they give the number to the police. It occurs. It occurs many a time. For example, if the vehicle number is given as, for example, 5392 instead of 5382, the actual accident occurred by 5382, but due to mistake or from the information gathered by passers by, the number was given as 5392. The owner of the vehicle of 5392 would suffer. He would say that I have not caused accident or the accident is not caused. But how he would prove that the burden of proof shifts on him? In case of civil liability, we are talking about civil liability, not in criminal. Suppose in criminal court he has been acquitted by the court on the basis of absence of proper evidence. But when civil liability occurs, the burden shifts that his vehicle was not used or his vehicle didn't commit accident. It is very tough to prove this situation. So in case his vehicle is not insured, on the basis of third party insurance, he has to bear the compensation. So I would like to suggest everyone on the platform that at least make sure that our vehicles and should be insured. At least third party insurance should be there, and the four wheelers must be 100% covered with a third party insurance. 100% covered should be, or it should be purchased with third party insurance. If we are if I would like to say that we should take self insurance, driver's insurance, cars insurance, but many times we see that when vehicles are 5-10 years old, we didn't purchase insurance, but we should purchase third party insurance always as far as four wheelers are concerned. But since I, I gave you illustration, there are many situations where where two wheelers got trapped in false cases, and at that situation, third party insurance comes into the. So I would like to say that third party insurance for two wheelers must also be purchased. And recently, by the guidelines of Honourable Supreme Court, if we would purchase today any vehicle, whether it would be electric vehicle or whether it would be two wheeler, four wheeler, car, bus, truck, etc., first year is covered with the vehicle is covered with full insurance along with third party insurance, and next, second, third, and fourth year are covered with third party insurance. It is mandatory. So I think since 2019 or 2018, it is mandatory that every vehicle is insured for 4 years insurance, 4 years third party insurance from the date of birth. This information is shared just for the knowledge on the platform. Uh, that's that's what I would like to say on the concept of negligence. Any questions? If anyone wants, are 100% invited.
Jayshree, your mic is off.
Rakesh Pariyani sir, if you could
Ji,
stay more for a longer time so that important discourses can be done within a time frame that we have been allotted. So the questions will be taken at the end of the three discourses.
Okay,
Can you
okay,
stay?
sure, ma'am.
Can you stay here?
Ma'am, I would try. I would try to stay here because I am traveling. Actually, actually, I am on a tour. Uh,
Mhm.
so that's why I would try that. I would try to manage that up to what time I could be on the platform. I would try my best.
Okay, I'll just ask if anybody wants to. Uh, Rajinder Mathur Saab, we welcome you on board. It's a pleasure and privilege to listen to you and to be enlightened by your 40 years experience, as we have been told that you have been a real light for the courts of Rajasthan state, as well as in internally also you have been helping out industry of law with all kind of academic and guidance. Sir, if you would like to comment on Rakesh Pariyani's talk, you've been
Well, it's a
regular.
privilege. It's a privilege, but I normally restrain myself from asking anything to the teachers. And he has so well explained everything, the concept of the law and the liability under the Motor Vehicle Act and the new sort of the liabilities. I don't have any question. But thanks to him, he has explained it so well.
Sir, I have a small question to Rakesh Pariyani, sir.
Yes, ma'am. Yes,
You
please.
said that there should be a third party insurance.
Yes, ma'am.
Actually, you skipped this whole phrase to explain. Can you still have 3 minutes to deliver on this?
On the point of third party insurance.
Yes, sir.
Okay, okay, okay. Sure, ma'am. Sure, ma'am. There are every insurance when we would when we want to purchase any vehicle, then it comes along with a mandatory insurance policy. When we purchase it, the insurance policy covers with three types. First is vehicles insurance. In case of any theft or in case of any damage to the vehicle due to the accident, the vehicle is also insured. The value of, for example, the value of vehicle is 10 lakhs. Then it would be mentioned on the insurance policy that in case of accident, in case of the whole breakdown of the car or the theft of the car or the theft of the vehicle, the insurance, the value of the car would be 9 lakh, for example. It would be mentioned on the insurance policy. In that situation, if the car damages as a whole, the person, the owner of the car would get 9 lakhs, or the amount up to which the accident is, up to which the damage is caused. For example, the damages of 1 lakhs are caused, then he would get 1 lakhs amount up to 1 lakh. This is first part of insurance covered. It is for vehicle. Second is for the person or the driver or the co-passengers who are sitting inside the vehicle. Insurance policy mentions everything on the policy note itself, that how much amount would be paid in case injury or death of the driver occurs, injury or the death of the co-passengers occurs. And this is the second kind of insurance, second part of insurance, which is mentioned in the insurance policy. And the third is third party insurance. Third party insurance. Every insurance policy comes with third party insurance. Means we can purchase either third party insurance or the whole policy. If we are purchasing whole policy, then then the third party insurance is covered in it, is in itself. Means it comes with it within the insurance policy. If we are purchasing only third party policy, then third party policy means if any death or grievous injury or any minor injury to any person or any vehicle is caused due to the vehicle for which third party insurance is purchased, then the insurance policy, insurance company is liable to pay the amount of compensation to that third person. That third person means to whom the damage is caused, the injuries are caused, or death is occurred. Third party insurance simply means the insurance company is liable for the damages or for the injuries to the person, to the third person who is not the part of the, who is neither the owner of the car, not the passenger, nor the vehicle, only the third person to whom the accident is caused. So third party insurance is mandatory for every vehicle which is registered in India or which is running on the road. In case we feel that our vehicle is old, it is 15 years old or 20 years old, now it is not in position to drive on road. So there are rules of regional transport office that it should be registered as scrapped vehicle. Till then, we have to purchase insurance policy, whether it is on road or not, because you cannot prove that it is not in we are not in position to run our vehicle on road.
Right, sir. Sir, is one more little information that we would like to have from you. Is there any centralized way through online process to get the insurance of the purchased car? Do the companies the automobile companies, they have their own way of centralizing the insurance to buy insurance? Like if
No,
actually when we purchase they provide us, but after 5 years 4 years they stop looking into the details of their buyers, and they stop asking the buyers that have you got the insurance or not. So what should the then owner of the automobile should do? Is there any kind of a online process, just like we do with the income tax card? We fill the form online to get our ID of income tax card.
actually there are many online sites which are selling insurance policies. We can purchase insurance through online mode or offline mode as well. For example, National Insurance Company, and I think IFCO Tokyo, HDFC, all these banking institutions are also providing us on offline modes insurance policies. We can purchase insurance policies on online mode on their sites, or there are many insurance sites. For example, I think I think it is pesabazar.com, or many more such sites. If you will only type online insurance, buy online insurance policies on Google, then many sites would be there on the screen. We have to share our photograph, our RC book, and last previous insurance policy, etc. We can purchase the insurance policy online. We can compare also many insurance policies, and we can purchase it on online mode. They are
Right.
all working in today's era. As far as the centralized rules is concerned, the showroom or the agency who is selling the vehicles has nothing to do with insurance, since it is mandatory for them to sell vehicle which is insured. That's why they have tie up with certain insurance companies, for example ICICI or HDFC or any such insurance agency, and the person uh, of that particular institution, for example ICICI, sits on the showroom. They do all the paperwork on behalf of the showroom. So we think that insurance is provided by showroom, but actually it is not provided by showroom. It is provided by that particular bank or financial institution or insurance company.
Okay, sir. So we'll now shift to next speaker.
Sure.
We, Professor Rajendra Mathur sir. He's been a very senior advocate of Rajasthan State High Court. I welcome you and I request you to enlighten our audience. They are very much enthusiastic. I also welcome the Dean, Faculty of Law from Bhupal Nobles University, Dr. Ashutosh Mitulia. He has graced us by his presence. I thank you, sir, for coming here. And I would request you to please chair the session, the next that is going to be taken up by our Rajendra Mathur sir. Yes, sir.
Thank you. Thanks a lot. My thanks especially to the Bhupal Nobles University, Professor Naresh Bahadur, Shri Prabhat Singh Ji Rathod, my senior in the Law College at Udaipur, respected Kala Munet ji. She was my senior in while I was prosecuting the LLB. Dr. Jayshree Singh, Dr. Kamal Singh Rathod, Dr. Ashutosh ji, and all participants. Thanks a lot.
Namaskar, sir.
I have a grievance. And before I come to the issue, which is changing concept of liability and its variance. The grievance is too short and a little time was given to me to prepare the subject. But then as a lawyer, sometimes we argue without preparing the brief. And my experience is when you argue without preparing the brief, you speak a lot.
Sir, you are allowed to speak.
Thank
You
you.
can take your time, full.
Thank you. The subject concept of the liability in its variables is a vast subject, and from where it began. The concept of liability began with the civilization. In a civilized society, only in a civilized society, the concept of liability can exist. The jurisprudence behind the liability is a principle of the law And that principle is ubi just ibi remedium. Where there is a right, there must be some remedy. That is the principle. For fostering the liability, it is not necessary that a society should have a codified law. The very existence of civilized society is sufficient to fasten the liability. If we are civilized, we must feel and we must owe the liability to remain civilized. The liability may be towards individual, liability may be towards the society. Good behavior is a liability. And if you are a disciplined and having a good behavior, then nobody can fasten liability upon you. Liability, as we all know, is the responsibility that is fastened by the law for a wrong done towards the another. And as I said, this another can be a society or individual also. The liabilities can be divided very conveniently in two parts. One is the civil liability and the other is the penal liability. Here our subject is not regarding the penal liability, that is under the Indian Penal Code, the civil liability. But I must share with you from where the concept of penal liability came. Before the Indian Penal Code was enacted, which is largely upon the Anglo-Saxon law, the British Penal Act was existing. And the British penal law has not been codified by the House of Lords or House of Commons. They are all precedences. And I must share, probably many of us know that the penal code is basically based on the literature. Shakespeare has contributed to penal laws. A question would crop up how Shakespeare, who has written plays, contributed in the penal law. So I will take you to, Madam, am I permitted to talk on the jurisprudence instead of the particular law?
Yes, sir. You
Okay.
have a free flow of your thought process.
Thank you. If we have occasion to read Macbeth, Macbeth is a story where the queen hired the services of witches. To kill the king, rather crown. It's a long story, but she did not act directly. The witches moved the banyan trees, which terrified the king, and king died out of fear. During the trial, the queen and the prime minister, her parent, were convicted on the ground that your intention was such, and you are knowing it well that this act will cause death of the king, therefore you are responsible. So the responsibility under the penal law, under the British penal law and Indian penal code also, the source is literature. All liabilities, whether it is civil liability or the criminal liability, the source is are not the law framers. Law framers derive the knowledge from the literature, from the teachers, from the knowledgeable persons. The courts also decide on the basis of the knowledge so derived from the law framers. So law framers get it from the society, the wise people, and the court get it from the law framers. But law of tort is one such law which is not fully codified. And therefore, I come back to the civil liability. What is the difference between civil liability and the criminal liability? I am conscious of the subjects, the liability and its variables. The difference between the civil liability and the criminal liability is, in the criminal liability, the wrongdoer is punished. But when a wrongdoer is punished, what does the victim get? Victim and its family must necessarily be and suitably compensated, and therefore civil liability. A particular act can be prosecuted both in the criminal side as well as the civil side. And the person who has committed, the wrongdoer, is liable both under the criminal law and the civil law. The economic factor of the liability created the civil liability. And that is the distinction. The great writers, Austin, Salmon, they all have explained it. But the precise difference is punishment and the compensation. That is the damages. Now, these are two kinds of the liabilities, and after the liabilities, as I said earlier, with the progress of the civilization, with the advancement of the awareness, the remedy under the civil law for the wrong done is assuming importance and is achieving new dimensions. Otherwise, there was a time when the principle was tooth for tooth and eye for eye. But with the advancement of the civilization and awareness of the people, which is more important, that is the awareness of the people is the new variant and new variables of the concept of the civil liability. Therefore, when we are talking about the liability, first ingredient is awareness. We must be aware of our rights. Unless we are aware of our rights, the civil liability cannot be fastened and we cannot raise the issue at the proper form. Now, this takes me to another concept, that is, in the criminal law, mens rea is an essential ingredient. But whether under the civil law also, mens rea is an essential ingredient or not, that is another difference. When the issue of civil liability is raised, the principle of mens rea goes behind the curtain. Mens rea becomes almost irrelevant until and unless the principle of an act done in good faith is raised. That is the only exception. Now, the newly developed concept of the liability under the civil law therefore ignores the intention of the wrongdoer. Intention of the wrongdoer is irrelevant. And that is the difference between the penal liability and the civil liability. If an injury has been caused and the loss has been sustained, wrongdoer is liable to compensate. If wrongdoer is liable to compensate, then what are the forums where the wrongdoer should go? Agitate the issue. The difficulty as far as the Indian laws are concerned is that we enact so many laws, and after enacting them, we just forget them. In our country, if anybody talk about the law of tort, whether a law student, whether a teacher, a judge or a lawyer, or even a student of the law, would think about only one particular law, and that is Motor Vehicle Act. Motor Vehicle Act is the only law in India which can said to be and which is being used as a true law of tort. And Motor Vehicle Act also accept the principle of strict liability. I'll come to the Motor Vehicle Act little later. Now, what type of the liabilities are there? The liabilities are of three different types. One, strict liability. Second, absolute liability. And third is vicarious liability. When we talk about the insurance, when we talk about the compensation, it is all vicarious liability. But then what is the strict liability? Strict liability is based on a principle that ignorance of law is not an excuse. Now, this is the principle which is backbone of the entire concept of the civil liability and damages. No one can say that I am not aware of the law, and therefore whatever wrong I have done, that has been done in ignorance of the law. In the civil law, ignorance of the law is not a defense. And that is not an excuse. Ignorance of fact is of course an excuse. Therefore, we must necessarily distinguish between ignorance of law and ignorance of fact. One of the defense is ignorance of fact. Well, I was not aware that you are coming from another side. I was not aware that this particular act will be done by the person who has sustained the injury, and that is known as a contributory negligence. And therefore, the entire concept of the ignorance of fact is based on the contributory negligence. You have committed a negligent act. You did not inform me about this fact, and therefore injury has been sustained by you. Therefore, these are all old age principles. Now, what is the responsibility toward the third party? Now, the responsibility toward third party is very soul and spirit of the principle of liability. I am responsible towards my child. I am responsible toward my neighbor. You all are the students of the law, and of all persons with the knowledge are very well know. You all know the case of the ginger beer. I read it when I was a student of the law, thereafter never ever read it. I can take care of the persons who are sitting nearby me, who is my neighbor. But I am also responsible towards a person who is not a neighbor. And that brings the concept of the third party liability. And when concept of the third party liability is there, then the concept of civilization, as I said, creeps in. For example, a vehicle driver causes an accident, injures a person, and also damages property. Now, what I'm going to say is the new concept of the liability. If a driver causes an accident, he is definitely liable towards the pedestrian or the person who has sustained the injury. But while driving the bus and during the accident, it hit a pole or ramp into a house, whether the driver or the owner of the bus is liable towards the electricity company or the house which has been damaged. This is a new concept, and this takes us to the new variables of the concept of the liability. In our country, of course, the liability of the professionals towards the services which they are rendering has not been given much recognition. But the liability of the professionals toward their clients and third parties is gradually getting ground. For example, now if a bus driver hits and rams bus into house, causes death on the road, whether the owner of the house is also entitled to claim the damages, and the owner of the house in turn can get the compensation from the insurance company. These are the new issues. Not only third party, but this is now the fourth party which is coming. In most of the countries, such as Australia, Britain, US, and few other countries, this concept has fastly growing. In the US, nowadays, most of the accountants and auditors, they are getting insurance for professional services which they are rendering. In our country, we have never ever heard of such insurance. And insurance companies will probably have not even dreamed of such insurance. Why? If while availing the services of an auditor, a loss is caused to that company, and a purchaser of a share of that company sustain the loss, whether that purchaser of the share can say that on account of the wrong report of the auditor, I purchased the shares and sustained the loss. In the societies where the law has advanced more than our law, the courts have recognized such right and liabilities. That is known as the liability of the professionals. Liability of a doctor, liability of a lawyer, liability of a paper setter who has, nowadays we have the multiple answers of a question. And while setting a paper, if all the four answers of in a multiple question are wrong, and that causes loss to the students in a competitive examination, whether can you sue the teacher or paper setter that on account of your this act, I have sustained a loss. In a few countries, not by law, but by the courts have evolved this principle. Yes, auditor is responsible. A doctor is responsible. A lawyer is responsible. A paper setter is responsible. Because on account of their wrong, may not be intentional, a wrong has been committed. So these are the new fields of the liabilities which are slowly gaining the ground. I would also welcome the International Institute for Advanced Legal Studies, Argentina. Welcome. It's a pleasure to see you.
Thank you very much, dear Professor. Good morning, good evening, everybody.
Good morning and good evening. Thank you.
Good evening, sir.
Good evening. Good evening. Now, as far as the Indian law is concerned, it needs to be developed in favor of the third party rights, which I have explained. A professional must render the services to the optimum level of its perfection. And therefore, when I said to begin with that when a lawyer argue a case without preparing it, the lawyer would just kill the time and argue a lot. Madam permitted me, but then that will fasten a liability upon a lawyer. No professional should render the service and provide the services without first preparing and being convinced that yes, I am rendering services which are the right services for which I have been engaged. And a person is not doing that, that is not only ethically wrong, that is a civil wrong as well. This is the new variable of the law of liability, which must gain the ground in the Indian courts also, which must be recognized by the lawmakers also. Now, apart from the professional liabilities, the difficulty in the Indian courts is, moment we talk about the professional liabilities or a liability to claim damages, the biggest impediment is the court fee. If a person is required to pay court fees, which is calculated on the basis of the damages claimed, for every 100 rupees, 7.5%. So every 100 rupees, 7 rupees 50 paisa is the court fee. And if I have sustained the loss of 1 crore, first I will have to deposit 75 lakh. This is punishment to the person who has sustained the wrong, who has sustained the injury. Therefore, until and unless the court fees is exempted in such cases, the law of tort cannot grow. To grow the law of tort in our country, and growth of the law of tort is directly and proportionately connected with the growth of the civilization. We must necessarily dispense with the court fee. That is what my thought is regarding the wrong and the subject of liability. Now, this takes me to the another aspect. This is really a very interesting subject, court fee, etc. But the restriction of the time, of course, is there. So I'll touch the another point now. The another issue is, if a wrongdoer is doing something under the command of another person, who is responsible? That person who is giving command is the master. So master's liability has been recognized in the law. Now, why master is liable? He has not done anything. What is the jurisprudence behind it? The jurisprudence behind the master's liability is the employer must be first of all cautious while engaging an employee, that I am engaging a right person. So his first negligence is in not engaging a right person. If an employer is not engaging a right person, definitely is negligent. The second reason is financial status of the master. A person who has capacity to pay must pay. Third is, an employee acts under the command of the employer. But master can always raise an excuse and escape from the liability. under the convenient excuse, and that is whatever act has been done was not done in accordance the manner in which I ordered to do it. But then this is not an excuse. And around 100 years ago, this was a right excuse. But nowadays, this excuse is not available. If you are a master, on the first principle that you are responsible to engage a right person who knows how to perform the work, will hold the ground. And on the basis of that, master becomes liable. Unauthorized act is not an excuse. The next liability, which is also a new concept, is the liability of the property. And my request to all law teachers and all law students would be to teach this thoroughly to the students, and if possible, this should be made known to the people also, that it is not the person who is liable, it is the property which is liable. Say, for example, if a person after doing wrong is expired, died, then who will pay the compensation? The heirs who are enjoying the property must necessarily pay also. Whosoever succeeds in the property is responsible to make compensation. And therefore, even a dead person is liable. That is the principle. Death is not an excuse. Wrong selection of the work performed by employee is not an excuse. So therefore, there is no moksha from liability. Until and unless you discharge your liability, there is no moksha in the law. That is the principle of liability, and which must be emphasized. This covers the issue, and another issue, that is economic loss is a ground for damages.
So you have got 2 minutes. So 2 minutes.
I'm finishing it. I told you that you have permitted me to speak without preparing. So I will speak, but I'll conclude it. Now, therefore, delaying completing the project by a contractor is an excuse. There is a fourth type of the compensation and civil liability, that is liability toward the society. And most convenient example of that is the forest law. In our country, the Mines and Minerals Development Act has been amended. Section 7 and Section 15 have been enacted, which says that anyone who pollutes must compensate, polluter must pay. Every mine holder to whom mines is allotted must necessarily pay because he is doing a wrong to the society. This is known as District Mineral Fund. People of Udaipur must have knowledge of it because they are suffering. Mines is being done in the entire South Rajasthan, especially in the Udaipur. And every mine leaseholder is under an obligation to pay to the District Mineral Fund, and they do pay to the state government. But unfortunately, no state government spent that money for the environmental improvement of that particular area. In Chittor, nearby Udaipur, I am told, and I have seen also, there is a lot of pollution on account of the cement industries. They do pay to the government, but the people are not getting benefit of it. So this compensation to the society, that is the issue which must be raised. On any other day, if Madam Jayshree Singh would invite me, I would definitely explain the concept of the liability toward the society. It has developed tremendously, but no government is taking it seriously. Thank you.
Yes.
These are the concepts of the liability and its new variants. Thank you.
Sure, sure. Sir. I will definitely invite you in person and soon, because it's urgently required, as a lot of mine laborers has been injured or been facing in post COVID or pre COVID times lot of hassles with regard to their health care. So I would like to definitely call you here in Udaipur soon. And I
Thank
think
you.
my dean of faculty of law, Bhupal Nobles University, perhaps is there in screen and would be listening to you, and he should think about it.
Thank you.
Rajendra Mathur sir, I request you to please stay longer to listen to further to discussions if you can. Indeed, it's a dinner time for you. We cannot let you to skip that also. So, but you keep behind the screen listening to us and then come in back.
Privilege. It would be a privilege. Thank you.
Right, sir. Thank you, sir. I invite our next speaker, Dr. Pragya Singh. Her full name is she's Assistant Professor Pragya Parijat Singh. Are you there, Pragya Singh?
Hi, ma'am. Can you see me? Good evening.
Yeah, welcome. Good
Thank you so
evening.
much.
It's a pleasure to hear
Likewise.
you, listen to you. And it's a coincidence that we have been looking for some O.P.Jindal teaching faculty of law. And coincidentally, Dr. Kala Munet referred you. It's our real good opportunity to meet you. I would like to give a short, brief profile of yours to our audience, that you had graduated from University of Delhi, and then you did your master's in legal studies from University of Cambridge, and that you had recently finished with it, and then you got your appointment in O.P.Jindal. Even though before that, I think you would were also in Supreme Court practicing as an advocate. Is it, Pragya? Can you?
Absolutely, ma'am. Right.
Yeah. So it's a real great opportunity to listen to you, and especially you have a lot of in your credit and acclamation with regard to your research papers titled as Decriminalization of Bagging in Delhi, which you wrote in 2018. Then another paper, Inhuman Condition of 1382 Prisons in India. So I think you have got good understanding of historical facts. That's why you took the prison case also of pre-colonial times. Then another case you had taken with regard to some kind of Environment and Natural Resources Property Act, a Polavaram Dam case, 2017. And then another paper which is very known is T.N. Godavarman case on forest rights. Bandhuwa Makti Morcha versus Union of India. So you are a really acclaimed person. Thanks for coming and giving us opportunity to hear you. So take the platform. Go ahead.
Namaste and thank you so very much, Dr. Jayshree Singh. Just a small clarification. I'm not a PhD, so I'm not a doctor like you. But nevertheless, my heartfelt thanks to Bhupal Nobles University and all the members from the executive committee who thought me worthy enough, because I think probably I'm the youngest one right here. God has been truly very kind and has given me opportunities at a decent age, and I've been selfish enough to grab it, and yeah, so far things have been nice to me. So thank you very much for calling me at this portal. So this also happened accidentally to me. And another friend was supposed to come, who's also a very renowned Supreme Court advocate. And since Sir had his surgery, so he apparently suggested my name. So that's how the event happened to me. And before getting started, my heartfelt thanks to the executive members, Professor Naresh Bahadur Singh sir, who's the president of BNU, our honorable guest of honor, Shri Parbat Singh Ji Rathore sir, who's the registrar of BNU, uh, Dr. Kamal Singh Rathore ji, sir is an associate professor, and Dr. Jayshree Singh, ma'am ko kisi introduction ki zarat nahi hai. Other than that, I'm also connected to Professor Salvatore Tolani, and I'm glad that sir has also joined the session. And good evening, sir. I was patiently listening to to Senior Advocate Rajendra Mathur, sir, and I think the major portion of the script that probably I wanted to start, sir has very nicely given a jurisprudential aspect to the topic that I have in my hand right now. So I would not like to take much time and get started with the topic that is given to us in hand. What are the changing concepts of liability in Indian context? Just a tad bit of history before we delve into the main topic. I would not like to make it super boring since I am also a professor of law. My target audience are the students, so they really dread about the topic civil law whenever they hear it, all the more civil procedure court. So that's one of the most notorious subjects. They would want to know more about IPC, CRPC, but civil laws generally irritate them or they find it very annoying. However, to the general parlance of people, the generic notion is that there are two types of laws in India, civil law and criminal law. And since we have civil laws in our hand, civil laws are nothing but laws that pertains to individual or private entities. It does not involve any action or any action that is taken basically against the state. So telling in a very simplified manner, if I say that we are taking into account any criminal uh, law, we would always make a state as a party because it is a wrong done against the state, and henceforth it is expected from the state to come into picture, uh, to be a part of the proceedings. Whenever we are talking about civil disputes, it involves individuals, private organizations, between two entities. So in the most simplistic terms, if I'm putting it, if you have a verbal dispute with your neighbor because he apparently, had thrown the garbage in your property, what is it? Is it a criminal offense? The answer is no, it is a civil offense. How did it came to India? What all have been the history associated to this subject? If we look into it, we'll find out that for the first time it was the year 1859. Back in those days, our country was, of course, a part of Commonwealth nation. We were governed by United Kingdom. So we did not really had any own law per se for that matter, and we were subjects to the crown. And that's why there was a proper hierarchy of the court. We had presidential courts, we had provincial courts, we had mofussil courts. Different types of courts were there, and over the period of time, it was felt that not just criminal matters, but matters pertaining to individuals are coming. And that's why we needed a separate category or separate type of law which was specialized in civil laws. And henceforth, in the year 1859, the first foundation for a civil law was laid down by a gentleman who belonged to the Britishers. And after several amendments over the period of years, finally it was the year 1908 when we gave to ourselves the Code of Civil Procedure. So it was enacted finally in the year 1908. Now, what happened between all these years is something very interesting. Our country eventually got independence in the year 1947. And just like Rajendra Mathur sir has mentioned, that we were British subjects and laws were made out of literature. So these British officials who were governing us at that given point in time, they derived majority of these laws from literature. So if you read English literature, if you've ever read it, you'll find that there's a lot of overlapping or commonality of Indian law, which at the same time may be very funny also. Similarly, if we read Lord Macaulay's Indian Penal Code, which was made way back in the year 1860, we still say that there are a lot of archaic and redundant provisions, not very much in consonance to how things are at present in India. But all in all, at least a good thing in hand was that in the year 1908, we finally codified, we had a substantial piece of law that dealt primarily with civil laws in India pertaining to individual disputes. Now, if we categorize these civil laws, we'll find it out that they're broadly of four types, and these basically pertains to the contractual law, property law, family relations, and civil wrongs. So, in case we have our audience as law students, for the most simplistic terms, I would like to give example that when we are talking about property law, we have the Transfer of Property Act, we have the Indian Contract Act, we have family laws, which consist of personal laws, the Hindu Marriage Act, the Muslim Act, so on and so forth, and the fourth one being the civil wrong, for which we read the law of torts. All these combined together are called as the civil laws in India. Specifically, if we talk about the Code of Civil Procedure 1908, it is something which acts as a blood and flesh to the skeleton which is provided by a substantive law. And basically, laws are categorized into two parts: substantive law and procedural law. So, there has to be a substantive law, which is then followed by a procedural law. So, it is in very simple terms, if I have to put it, it's like a scooter that has a stepney associated to it. So, if we do not have a scooter, we will not have a stepney. So, it is important to have substantial provisions which are followed by procedural aspects. For example, we have the Indian Penal Code that basically tells in section 299 and 300 as to what culpable homicide and murder is, and as to what the different punishment or penalties pertaining to it. And at the same time, the procedure that has to be enacted is provided in the Criminal Procedure Code. When we are talking about civil laws, there is a mix of both substantive and procedural law, which is provided in Code of Civil Procedure itself. So that is one law that encompasses and acts in a way a kind of umbrella law, and it contains uh, different parts. Basically, there are some sections that are provided in the beginning. Nearly 155 sections are provided in the Civil Procedure Code, and they are later on followed by different types of orders and rules, which basically tells the procedure pertaining to it. So the history has been really very beautiful. Now, when we are talking about civil laws, they do not attract punishments. They do not talk about rigorous imprisonment. They do not say that, somebody uh, will be going to the jail if you've not done something. All in all, civil laws basically talk about damages and compensation. So it's a damage that has happened, due to which state cannot be prosecuted and individual can be prosecuted, and now that a damage has been done, the same should be compensated in a pecuniary manner. So, as Mr. Mathur has mentioned, that there's a very beautiful legal maxim that most of us are aware: "Ubi jus ibi remedium," that wherever there is a right, there is a legal remedy. It means that yes, wherever there has been a situation that our rights have been breached, it is of course provided by the law that we can avail benefits if there are available anything which is present legally. So, rather than going rounds and rounds about how things are in the civil laws pertaining to India, I would primarily be focusing about how things have changed over the period of years, how there has been a paradigm shift. So many amendments have taken place over a couple of years, and with various committees, especially the Malimat Committee or the Law Commission reports over the period of years, we found out that the original draft of 1859 and the final draft that was given to us in the year 1908, and as to what it stands currently in the year 2022, a major overhauling has been done. So yes, it was definitely made by a Britisher, which contained a lot of archaic provisions that derived in a way from literature. But now, suiting Indian circumstances and scenarios, we've done a lot of amendments, which clearly shows that there has been a paradigm shift. So a lot of focus was not definitely given to Article 14, Article 19, Article 21. But over the period of years, we'll find out that concepts like principles of natural justice, या नैसर्गिक न्याय जिसे कहते हैं, all these concepts have now found out place in civil laws. It's a matter of serious concern. The courts are taking civil laws very seriously. And since tortious law is not even a codified piece of law in India, it becomes very difficult to sue a party for the sake of damages, just like we have the American and the British jurisprudential system. However, there are also certain topics that are provided in both civil law and criminal law. Just like we have defamation, so there can be a civil defamation, there can also be a criminal defamation. If there is a situation of medical negligence, a person can also file a FIR and get the parties associated undergo trial in a criminal court, and at the same time, for any loss that this party has suffered due to medical negligence, they can also receive damages in the form of pecuniary benefits. So you see that there is some sort of overlapping between certain provisions which are there in both civil law and criminal law. So when I'm saying that there has been a paradigm shift, it's important that we need to understand that over the period of years how things have changed. So there is one very beautiful, and I'm talking about the practice side, and I'm talking as a practitioner's perspective here, that a lot of people sometimes get confused, because we had given to us in India in the year 2005 a very beautiful act which is called as the Domestic Violence Act. Now, this Domestic Violence Act basically deals with domestic violence between the spouses which are married or in the nature of marriage within a household, having a shared kitchen, having a shared household, basically staying under the same roof. Now, a lot of people get confused that this Domestic Violence Act pertains to criminal proceeding. No, it's a civil remedy. So you see how beautifully over the period of years the state felt that it's very important to protect the subjects. So similarly, if there's a woman who is staying in a matrimonial house and is subjected to domestic violence by the husband and the in-laws, not just have a right to file a case of maintenance against the husband as per section 125 CRPC, for which there will be a separate proceedings. At the same time, she has a civil remedy that by staying under the same roof with a purview of section 20, she can also ask for some sort of maintenance, and the court very well can grant her compensation by the virtue of this civil law, which is Domestic Violence Act of 2005. Similarly, a lot of environment related regulations have taken place, and sir was clearly discussing as to how vigil the states are when we talk about environment related liabilities, the master servant relation. So if you are causing any type of damage to the environment, the states are very particular about this thing in this regard. And absolute liability, concepts of strict liability, absolute liability, and no fault liability have also developed over the period of years. And especially this 1980s to 1990s was the time when India saw that there has been a rise in PILs, and people are getting really vigilant about different types of environment related laws that were grossly misused. So participative ways are also appreciated. It's also expected from people that now they become a part of decision making. And if you're causing damage to the environment, hefty compensations are need to be paid to the parties concerned. So I will talk more or less about the drawbacks that persist in regards to civil laws as of now that we have in our hand. One of the biggest issue is that these procedural laws, these civil procedural laws, are no doubt very good, very sound, and despite being so old, continue to be the same over the period of years. But the only issue is that in some or the other way they are providing justice in a form of tokenism. And it's said that justice hurried is justice buried. And Tariq is a cult. Tariq pe Tariq is a cult in India, and we had a proper movie in which Sunny Deol gave this dialogue. But this is very true when we talk about it in Indian context. So there has been gross pendency in the courts because of the delay mechanism. The logic is that these civil procedure courts are so technical, so rigid in its nature, that in a way they do not allow any type of flexibility. Logically, even the provisions of civil laws clearly mention that parties are not supposed to take adjournments for more than 3 times. So be it a petitioner, be it a respondent, not more than 3 times either of the parties are supposed to take adjournments. But since most of us have are practitioners, and we every now and then go to the courts, we see how grossly misused these provisions are. So, civil laws, despite being very effective, the implementation becomes problematic. So, there's a tokenism kind of justice has been taking place. Not just that, the provision or the flexibility that is provided by civil code, which allows for something called as the ex parte proceedings, that without even hearing one party, if court feels that it is important to allow proceedings to happen by listening to only one party, was also initially provided with a good logic, with a good intent. However, this is also one of the most misused provision. So when we are talking about paradigmal shift in this regard, we'll find out that generally these type of cases are grossly misused when we are talking about matrimonial disputes. So what happens is that husband and wife who files cases against each other tend to in a way persuade the courts that you do not hear other parties, and due to ex parte proceedings the pendency is also increasing. So these are different types of instances where we feel that these technical rigidities that are provided by the existing provisions of the civil procedure court has over the period of years caused some sort of problem in a way which definitely needs amendment or alterations over the period of year. Also, at the same time, idea regarding court fees, which was also discussed, is also something which is very important. So I am the one who has suffered in the hands of, if there's a case where I need to recover money, or there has been a breach of contract, and in case I want to recover money that I had paid. For example, I'll give you an instance that two parties are going to do a contract, and just before signing the ikrar nama, there's a logic called as bayana, or an advance money. And advance was given by party A to party B. However, party B refused at later stage despite taking money, and says, I'm not going to do this thing. So for specific performance of contract, if somebody is filing a case, first of all, this person needs to file court fees. And sometimes, if the subject matter or the pecuniary jurisdiction or pecuniary value of that particular suit is too high, imagine the amount of stress this person will have to overgo uh, in order to get justice. So, in order to recover the money that I only paid, I have been the sufferer, again, I need to pay court fees. Of course, the court has its own logic that I never invited you for adjudication of disputes, and even we have our own expenses. But at the end of the day, we need to understand that whether justice is actually getting delivered or not. It was precisely because of these reasons that some of the tribunals were established, which are quasi judicial in nature, and they said that we really want to get done away with procedural laws. So one such tribunal is the National Green Tribunal. So there were a lot of environment related litigations in India, and with that we established a National Green Tribunal in the year 2010, which has different regional benches as well. So these are specialized types of tribunals that look that basically adjudicates matter pertaining to environment. Now, the operative portion of these particular statutes that has formed the tribunal, that is National Green Tribunal, or the regional benches, is that they will not be governed by the provisions of Civil Procedure Code. Precisely this was the reason, because Civil Procedure Code is very beautiful, but at the same time it's so technical that by the time justice is rendered to a party, it takes years and years. As lawyers, I get very happy if I get a civil matter, because I know that the matter will not be adjudicated super soon. I will be making money because my client will keep paying me. So Tariq pe Tariq is a real phenomena in Indian context. That is why when we are talking about the National Green Tribunal said that we want to be governed by the principles of natural justice. The idea at the end of the day is eventually to provide justice to all. Law has to be accessible to all. If we are getting too rigid about the system, sometimes it may lead to a lot of problem. So that is why it got done away with this entire idea of trial, that service of someone will be sent, then both the parties will be called, pre-trial stage, post-trial stage. People do not even know what is a order, decree, and cost. All these things get very technical. So one of the biggest changes over the period of years, especially in Indian context, that we find is that despite having great civil laws in hand, sometimes they are also considering that it's very important that we take into consideration angles of human rights, civil liberties, principles of natural justice. So a very humane aspect is also given to civil laws. These environment related litigations that started, they just shot up in the year 1980s, with that notion that at the end of the day, at the cost of ecology, if we are booming our economy, it is not going to last for a very long period of time. So if we read the idea of absolute liability, it basically tells that come what may, no matter how much precaution you have taken, you will be liable for anything that causes miscreant, that causes trouble to people in case it escapes out. So if we read the Bhopal gas tragedy case, eventually this idea developed, which basically says that even if you are no fault, even if you've taken best of precaution, but if you've got something dangerous on your property, in your premise, and it escapes and it damages people, mankind, livelihood, you will be bound to pay to the people who have suffered in your hands. So sometimes we'll see that whenever a matter is filed, especially in the district court, uh, and we find out the judgment, and if we read the judgment, and then any party who's aggrieved goes to high court, and altogether different interpretation is given by the high court judges. So in my limited years of practice, especially in Delhi High Court and in district high courts, I have found out that despite having same laws, a very different angle was given by superior courts by exercising its inherent powers under section 151 of the CPC, while these district courts are very, very rigid about the technical nuances that are associated with civil laws. So what I'm basically trying to say is that uh, over the period of years from 1908 till 2021, the civil laws in India have gone through immense overhauling, and befitting to Indian interest, a lot of amendments have been made. They were initially made by the Britishers, keeping in mind the literature that or the jurisprudence that were very much rampant in their country. Then we got independence. Then, as per Indian situation, laws kept on getting changed. And finally, as we stand today, we'll find out that there have been more than 100 amendments over the period of years. So the raw draft that existed, it has in a way changed a lot. If I say that there are no lacunas, it would not be correct on my part. But at the same time, this is a very important piece of legislation, these pieces of civil laws that pertains to individual disputes in that regard. So that's all I have on my part to say. And thank you so much. If there's any follow-up question, I would be more than happy to answer. Professor Jayshree Singh, I'm not able to hear to you somehow.
Yeah, I'm here now.
Yes.
Thank you, Pragya, for such an exhaustive, elaborative, and very well planned discourse you have delivered to all of us. I think you have been into a lot of practice with regard to the environmental conditions that have been into questionable form in legal studies. So I think that your area of interest is majorly lying there. And
Definitely.
secondly, I think what I have derived that you have also dealt into some kind of gender lens with regard to tokenism, not only in getting the justice, but also in domestic or family affairs, in social conditions. The tokenism that prevails is your area of interest. It's wonderful that as a young, you may say, advocate, you are going to make a mark in
Thank
this.
you so
Both these fields are very emerging and contemporary and
Thank you.
very demanding, and you have got a lot of clients who would be looking forward to your guidance. I
Thank you so
congratulate
much,
you.
ma'am. Thank
Uh,
you so much, ma'am, for your very kind words. And I wish this was a physical event. I would have loved to come to Udaipur. That is one place that I'm really
sure,
fond of.
Pragya. You can ask me anytime. You can book your. You can ask me even to book for you a, hotel room. You're just like me, so I would
I
definitely like to invite you.
I went to Udaipur exactly 3 months before, and I had the time of my life. In fact, my roots are somewhat from Badmer, so I'm very fond of Udaipur for that matter. But thank you so much for giving me this opportunity, which came out of nowhere. But I would love to visit the campus and know more about our own heritage and our own state. My native belongs to Rajasthan, so yes, thank you so much.
One more affinity that
Definitely.
I would like to state here. Actually, my daughter, she completed her graduate from O.P.Jindal in
Oh
law,
wow,
School of
that's
Law, but coincidentally, you were doing masters at that
okay.
time.
That's great. That's
And
great.
so she is an alumni of your alma mater institute. And my point is that even if you would not, don't ever hesitate. Even I can invite you at my house also.
Thank you, ma'am. So
So
kind of
be
you.
free, and anytime you're visiting with family, do call me.
Thank you so much, ma'am. Namaste, and my heartfelt thanks to everyone for giving me this
Now,
opportunity.
on behalf of my co-host, there is a
Thank.
request.
Yes, yes,
Actually,
yes.
I have seen your biodata, and in that you have mentioned a lot of research papers you have been in.
Ma'am, these were landmark cases which
Mhm.
in which I got the opportunity to be a part of. And so I was in active litigation, and then one random day I thought that let me also take a master's degree, and I was fortunate to get a call from University of Cambridge. So I went there for my LLM, and from last 2 years since pandemic was there, so I joined as an assistant professor of legal studies. So my core area of expertise is procedural law only. I'm a teacher of CPC in O.P.Jindal. And now I will be an adjunct professor because I'm resuming litigation, but I will stay associated with academia. So, yes.
So, our little request to you that you have got O.P. Jindal Review Journal of Law.
Yes,
Right?
absolutely.
So, actually, we were looking for some context that how could we get into that journal. Especially our co-host, he wants to get added into that. Uh,
Uh,
he would
may
be
I know?
just entering in. He's
Yes,
waiting for his chance to be
yes, yes.
invited.
All yours to
So,
sir. Yes.
yeah, so therefore, I'm just extending his mind here that he wanted to be added into just that journal review of law, number one. Number two, if you can pass on to me some other journals, editors' emails, so that we can also go into those publications, how they process their all kind of data, and how what are their
Definitely, ma'am.
editorial codes,
Definitely.
etc., etc.
Definitely. I think one very good thing about O.P. Jindal is that it's gaining its prominence not because of course, money or infrastructure, but the good thing is about the scopus publications that they are doing. And the journal is double peer reviewed. It's actually quite nice. So I will connect you to the resource person. I do have your contact number. So I will also eventually connect you to the people of that journal, and I can definitely help you out bridging wherever there's any sort of access gap. I'll be more than happy to do that.
So you can email us all those editors' email phone numbers and some. All right.
All
And
right.
one last, I think I should ask on behalf of all audience.
Sure, ma'am, sure.
You know, because it's it's in a kind of a trend that if somebody is delivering a discourse, so some kind of query should be there
Yes,
to
ma'am.
just.
Yes, yes, yes. If I have an answer, I would definitely like to answer.
Now my question is, how far malicious motive fall in the line of no fault or without fault liability in the mental element of tort?
I would again like you to repeat the question.
How far malicious motive? Generally, the cases are, filed because of certain malicious motives.
Right.
But if you are the judge to win the case, not to lose the case, then how far malicious motive falls in the line of without fault or no fault liability?
With that, I will again go to two angles to this. This is state of West Bengal versus Anwar Ali, that basically propounded the difference between malice in law and malice in fact. So with the bifurcation between ma'am, if 1 minute can be given, I have somebody at my door. Please let me just open the door. Just
Sure,
one
sure,
second.
sure.
Yes, I'm really sorry. I had somebody at my place.
Mm-hmm.
Yes. So I was
Mm-hmm.
saying that in this particular case, a distinction was drawn basically between malice in law and malice in fact. So whenever we are talking about malice in law, it basically means that the law itself is problematic. There has been some sort of oblique motive. Has been some sort of corrupt or ill intention for that matter. So, as you all are aware, that whenever a crime is constituted, it needs to have two components, which is mens rea and actus reus. Basically, saying that there has to be some sort of mental element involved, and at the same time, a covert or an overt act. Until and unless both these two things are not done, it will not constitute, it will not really be called as a crime. However, the problem with malice is, or malicious intent is, that it is something which is very difficult to be arrived at. How do you know that the opposite? It's a mental element. So I think that you had malice, but how will I prove it? So the idea of proving, or this burden of proof, is actually a very slippery note. And that is why whenever these type of matters come in front of the judges, where they have to find out contours as to, and somebody is alleging that there is an angle of malice involved, it's a very slippery note. So they have to be super cautious before they come at the conclusion that yes, there is an angle of ill will or malified intent is involved here. So when we are talking about no fault liability or absolute liability in that regard, we need to understand that there is a intrinsic assumption that yes, let's, on the face of it, prima facie assume that you had no fault. We are not saying that you are personally responsible for it, but you need to understand. So there are certain components to no fault or absolute liability. That first of all, you are head of an organization, head of a particular premise, and you've brought something dangerous over your property. That is not a problem. We all get involved in doing businesses which may involve chemicals, so on and so forth. It's fine. You can have a dangerous thing over your property. But unfortunately, if this thing if this thing escapes out of that property, despite the fact that you have taken all due diligence, it will still be counted as no fault liability. But the angle of malice is something which is very difficult to prove, and that's why every factual matrix of a case finally helps down a judge to come to conclusion. So they will definitely, there are certain ways through which they look at it. The evidences will be perused by these judges, and that is why if they feel that there has been some sort of oblique or interior motive, or that this negligence was done by them despite knowing what the consequences will be, then in that situation, in that scenario, it will become relatively easier for them to come down to a conclusion. So that is my understanding, limited understanding over the topic
Thank
that
you.
you've asked me.
Thank you. Thank you.
Thank you
So
so much, ma'am. Thank you so much for
let's
calling me.
invite our co-host, an honorable professor, mentor, and the, you may say the origin, the source of this all spirit, of the spark. So I invite Professor Salvatore, please join in.
Hello, Professor Salvatore.
Good morning, Professor. Nice to meet you.
Good
Even on
evening
screen.
from India. Very nice to meet you too.
Even I must admit I'm worried by the charge that Professor Singh gave to me. So I'm not able to support such a charge.
not charging you with anything, Professor Salvatore.
No, it is I say Dr. Jayshree Singh.
Okay.
I feel
Professor Salvatore, you were from which? You teach in which college at University of
I'm a
Oxford?
I'm a fellow. I started since
Oh, nice, very nice.
I unfortunately I'm very old, madam. So I started on 2004 teaching by becoming a fellow, visiting an All Souls College, then on Magdalen College, and then I started after in 2008 to become a fellow of the faculty. So changing college.
Great. I've been in
Listen, I see.
Cambridge. I've been in Cambridge, but if at all I happen to do my PhD, it would definitely be Oxford this time.
Okay, it will be a pleasure. It will be a pleasure.
Likewise, sir. Likewise.
It will be a pleasure. Yeah, I've been I heard very interested in your introduction to the Indian system and to all the practice, and I appreciate very much the double view that you point upon the subject that is objectively needed. That is by the procedural perspective and the substantive one, because it's the only form through which we can focus on it. So I hope that we can further these arguments through the review that has been just said by Professor Singh, by Dr. Jayshree Singh, because
Yes.
of homonymy. Because of
Sir,
homonymy.
I think, sir, before I ask you to just start, I think there's one candidate or attendee, Seema Modi. She's raising her hand. Seema Modi, please turn on your screen or camera. Do you have anything to say?
Yes, ma'am. Good evening, ma'am.
Yeah. Yes.
Ma'am, actually, I could join very late. So I was having one query, and I continuously I was sending the message also, but I could not get any response. That's why.
Can you
Ma'am,
wait?
actually,
Pardon,
yes,
Seema.
ma'am.
Can you wait? Because our honorable professor is here. Has already been delayed for half an hour. So we can
Yeah, ma'am.
have
Sure, ma'am. I can wait.
Please
Yes, ma'am.
stay and tune in later on.
Sorry, Professor Singh. If there is a matter of precedence, of course, the gentleman
Okay.
allow the madam before. So
All right, sir.
I can
Seema,
pray.
you can come in. Seema. Right.
Yes, ma'am. Please ask your question, Seema ji.
Ma'am, I just wanted to know that whether there is any feedback form also which we have to fill up.
Sure. I will be passing on the feedback link all through social sites as well as through the chat box on 31st morning. Or maybe morning or evening.
Okay, thank you, ma'am.
Evening, I'll just email
Do
it.
you have a question as well, Seema ji?
No, ma'am. Topic related, I have no question.
Okay, fine. So I think Dr.
Thank
Singh
you,
has made it
ma'am.
clear. Yeah. You
Yes,
can
sir.
go ahead, Professor Salvatore. Yes.
Okay, thank you, thank you very much. I wish to today to having another page of the recap that we are carrying on concerning the structure that we are bringing from the first seminar to the first talk and our first meeting on also to this through all these form of liability that we are examining in these days, and that is the nexus of a causality, because I believe that nexus of causality matter of malpractice, also medical liability is assume a very intriguing form and a very intriguing case for all the analysts, all the interpreters who has to deal with this kind of issues. Of course, I wish to focus first of all the concept that will lead us through this examination, that is the concept of etiology. Being present of a fine linguistic like Professor Jayshree Singh, I must be very careful in adopting the concept of etiology, and so it is normally classified as conceptually of the cause or set of causes or manner of causation of a disease or condition. This is a technically medically adopted concept. In general, etiology, so also in law, is qualified as the investigation or attribution of the cause or reason for something, often expressed in terms of historical or mythical explanation. So we are facing also something that is transcendent to our discussion. But being transcendent, it is not to being evanescent. It only means that needs to be concretized in the forms that is much more aptful for the case under analysis. Before to go to malpractice and in the context, in the specific context, I would like to focus on some elements concerning nexus of causality or etiology, if you want, beside what we have said in this last days, in the more general form. The more general form, that is the form that is assumed normally as the basic norm in law of torts, that is, for example, corresponding to paragraph 823 in German civil code, or the most famous norm of truth 2043, paragraph 2043 in Italian civil code, that is the so-called Aquilian liability, as is also known in common law systems. Aquilian liability says about etiology, about nexus of causality, that for the configuration of liability, it does not assume any determinant relevance, the formal qualification of the legal position that is assumed by the subject, because I'm translating directly from the jurisprudence, because the reparation reparation is deemed only at the condition of the injustice of the damage, and this is an autonomous case that is characterized by the harm of an interest that is legally relevant. Why this is a more general norm or more general perspective adopted by jurisprudence important in our cases? Because we must first of all try to focus, even shortly, the conditions of the medical actor. This is the medicine man. When we request the injustice of the harm, we are already insisting in a clear distinction between justice and injustice of the harm, of the harmful conduct, or better, of the harm in itself. because conduct may be absolutely legal compliant, but is the result as a norm that is relevant for us. But this is the case in which many or almost all of the medicine men are inside in the moment in which they operate, because otherwise I cannot go to my dentist if I'm not ready to accept that I will be harmed by its activity for a better recovery of my health condition. So this is the first, and I repeat, very short element of our analysis that I wish to focus today. When we are discussing all malpractices, we are almost in every case, almost in all the cases that we are facing up and we are analyzing, we are balancing the harms deriving by a conduct, okay, between harm that are proper of an activity and normal, we can say, that are we routinely normal and that are accepted, and harm that are not, through which we try to find not liability, I repeat, but as a Dr. Professor Pragya Singh has very well focused just a few minutes ago, we are going to search for an imputation, that is a position in a process. The liability comes at the end. Another norms is the kind of another norms that I wish to focus is that say that the kind of link in the civil civil process deriving from the criminal process concerns the fact in their objective reality and their phenomenological reality taken into consideration in the criminal under criminal codes, while on the contrary, the justice on civil trial is fully free for the evaluation of the facts historically asserted in the penal crimes, in the penal trial, and in autonomous form. That is what to say to say what that under some what is a normal and overlapping. I suppose that I'm repeating again the verb that has been adopted by Dr. Singh before, the overlapping, that I absolutely subscribe, the overlapping of two kinds of judgment over the same cases. When I say cases, I say what technically we will say token in English common law as the concrete case, different from the type, that is the abstract case. Why this matter? Because even if we can standardize the conduct, even if we can have a routine, a binding assumption of the cases, we must case by case, even in malpractice, to start from the concrete case, from the token, and to see how it is can be or less, more or less subsumed under the abstract case, better qualified as type. Why this? Just to focus this kind of difference through which we watch through different, I see spectacles to the same case in civil liability and in criminal liability. Criminal liability as is governed by some kind of principles that are very different from civil principles, from principles govern civil liability. And first of all, criminal liability as the for our case today, for my explanation today, is characterized by the principle of taxativity, fragmentarism and taxativity. I cannot be imputed under some kind of crime if my conduct does not subsume to a very clearly defined in advance norm. Okay? The interpretation of the interpreter abstractly is limited to the mere subsumption of a concrete fact under a very clear defined ex ante in advance norm. This is a basic pillar, a basic principle of criminal law. nulla pena sine previa legge. Okay? The principle of imputation must pre-exist to the fact. On the contrary, civil cases are subjected to a very large possibility of interpretation. We have the limits of the case, we have the limits of the norms, but norms as not a literature that must be binding for definition, on the contrary of criminal law. So what is facing the same case of malpractice, the difference between the two kinds of interpreters? The criminal lawyer must find a case interpretation that has been set clearly and in advance, so developing an already existing norm and legislation through which operating by subsumption. Okay, the concrete case go under this norm. Civil lawyer must start, on the contrary, from the fact, because all the facts that he has under his jurisdiction as interpretation has a very large coverage, normative coverage, that is the Aquilian liability. And it is the general norm in matter of torts. Okay? And this is what is open a very big distinction between the two kind of approach that have been normally used to malpractice. The last general concept of etiology is concerning, I wish to express, to comment, is the nexus of a material causality between the conduct and the event. When we have this kind of materiality as a requisite, is when we have for every behavior that is antecedent, that is clear, that is near, that is intermediate, or even remote, okay? We have the clear connection between this conduct and the event, okay? So we have not the division that has been very how can I say, this is a topic that has been deepened very well by a senior Don in Oxford, that is Professor Tony Honoré, about remoteness. We have not a problem of remoteness, we have only a problem between the conduct and the event, even in terms of medical malpractices, but we need only to establish an objective relation between the conduct and the event in itself. Okay? This is the cause of the event independently by its time relationship with the event. Okay? The only thing that we need is that we need, of course, in the course of time, when we establish a more remote relationship, we must, of course, exclude other conduct and other event in the middle that can, we can see, interrupt the nexus of a causality. Okay? But it's not in itself the time as a factor that can be deduced also as an element of that is of discrimination, of discharging from the malpractices liability. Okay? Moving from this more general level to a more concrete one, I wish to focus in what is maybe is the more controversial and surely the most difficult area of interpretation in these cases. As you have seen in these days, I tried to put on our focus on our attention, even in conditions of not very well ordered relation conference, but in the cases of just to trying to communicate how difficult these cases are. What I believe are the frontiers of our common common advancement of studies in all the matters that we face it. And I must admit that what I'm going to talk about in in matter of malpractice is currently is one of the most hot issues that we must face in the case of malpractices. And this is the malpractices when derived from an omission type, not from a commission type. Very simple and very easy the explanation. I must also admit that when I was revising this talk yesterday, I was thinking about Schrödinger and the enigma of the cat. Famous example. What is the difference? Malpractice can derive from two, of course, from two elements. It is a medicine man who behaved bad, and there is a medicine man who didn't behave at all. Both are cases of commission and omission. Both are cases of malpractices. But as you can understand, what we are discussing, that is the basic issue of the interpretation in these issues, is the nexus of causality. So the nexus of causality between omission and commission is totally different. We can say that is opposite, but both converging, if are many times they are overlapping each other. So the delay in commission is a form of omission, or has been differently approached to the activity. These are very complex causes, and these are the elements that we are analyzing at the frontiers of the modern frontiers of malpractices in this time. What is the basic assumption concerning the malpractices as deriving from omission? In the case of commission, we discuss about hypothetical reasoning. Okay, we will say that the commission will have been different. Now we will have a different result, and we will have not the harmful event we are analyzing under legal interpretation. On the omission type, when we are discussing of omission as a cause of malpractice, we are no longer discussing the hypothetical reasoning, true hypothetical reasoning. The ex ante, the previous analysis on a probabilistic basis. We are not saying that where if differently has been put that behavior, the consequence will be different. The one that intervenes, this is the kind of raisonnement as interpretation that intervenes on the dutiful conduct. Okay? Through analyzing the dutiful conduct that has been not carried out, we are discussing if the conduct will be different, probably not. We have not this kind of event. But one starts from the event actually occurred, and this must be assumed retroactively in the causal link so as to be casually traced back to the omission. When we discuss the consequences of an action of a medicine man, we are discussing of something that is concrete and can be analyzed. Please try to put your feet in the condition of the parietal analysis of a third doctor, a third medicine man, who is giving his view in a judgment, in a trial. Okay? The event occurred must be traced back retroactively to something that has not been part of the conduct of the medicine man. This is one of the most important area revested by the omission activity in malpractice. I have the event, I must trace back this event to an hypothetical antecedent in which there has been an omission, and I must trace back to this the removing of this omission by a commission, let's say the treatment that has not been enlarged to the subject. Okay, and I must say that in this case, the harmful event from which I started would have never been happened. It's okay?
Yeah.
So,
I understand.
of course, you are free to interrupt me when I'm more obscure than usual. Yeah. So it is. We change our mind. We change our set of mind, and it is no longer hypothetical reasoning. Okay. In fact, it is inferred in the indictment. It is no longer probabilistic, but certainty. Okay? When the commission discusses a fact as a consequence of something that has been done, in the omission, we have this form of paradigmatic reasoning that enter not from the event to the hypothetical cause, not for having been put in on, but for having been not put in the situation. I prefer to assume a more larger, more abstract concept because, it is not only one doctor. There are a chain of doctors, anesthesiologists, the surgeon, the many other subjects who normally intervene in the context of this kind of professional activity that is medicine. It is important to fix another problematic rule concerning malpractices. Since it is extremely difficult to achieve a degree of absolute certainty, the existence of a causal link and therefore of liability between the antecedent and the harmful event may well be affirmed on the basis of a serious and reasonable criterion of scientific probability, demonstrating, above all, at an evidential level, that there are no other pre-existing, concomitant, or supervening determining causative factors. Okay? We have a very, very of course, I suppose that is very clear the level of concreteness at which we are analyzing the problem of liability and malpractices. The problem of concreteness in this case is, by this norm, want to have one result. Interpretation must arrive to one or to only one conduct that individuate a cause, because not always the malpractices as conduct is a malpractice as a cause. The medicine man may commit an error, a mistake, or whatever, but this mistake or error is not the cause of the event. If we are discussing of the most problematic event, the death, for example, we must be very careful in select what is the antecedent of the death. Even in a cause of a more general malpractices, there are many causes, behaviors of the medicine, who has produced other kind of harmful event, but not the death. Okay? In this kind of a linearity between the cause and the event that is under the analysis of the interpreter, of the legal interpreter, must also try to separate some other element that can be cause of something different. So we have to exclude, first of all, the preexistence of any, let's say, organical causes that has been not understood or focused by this medicine man, that can cause the harmful events we are discussing, the death in our case. It may be concomitant cause. Let's say that beside the mistake, beside what has been practiced by the medicine, something that it was not expected supervene. Okay? And in this case, the area of problematic becomes very different because malpractice behavior in itself cannot be isolated by the concomitant or supervening determining causative factor. Okay? So let's say that here we are closing the doors to traditional tools until now that I must assume that is no more the key of all of our the criteria of our criteria in evaluation in the evaluation of these cases, and it is the probability coefficient. Now it is clearly admitted in European jurisdiction that probability coefficient expressed by statistical law does not justify the existence of the causal link. The interpreter must verify the validity in the concrete case on the basis of the event that occurred and the available evidence. This is a very important requirement. I cannot properly qualify the requirement actually because it is not something that go back to something existing before. No. Here we have once we say the paradigmatic reinterpretation of the activity, because we have an inductive reasoning that is required in the justification of the causality nexus. Once we can say that given some kind of treatment, we have the probability to some kind of patient, let's say the cardiopathic patient, a doctor who has not anticipatedly examined the conditions, the heart conditions of his patient, given that pharmacon and given that result, we have the statistical law who tells us that there is this kind of event, the death of the patient. We can arrive at the same conclusion, but this form of reasoning, this form of articulation of the nexus of causality is not more admitted. We must discuss from the concrete case of heart attack, of heart disease that caused the harmful event, and from the concrete case to go by induction to arrive to the cause, not by statistical law, but through the available evidence. I wish to just to recall to your attention how large is the parallel case of criminal imputation for medicine subjects who in the course of these events, when something wrong occurred, try to masquerade, to try to hide the evidences that occurred in that case. Because everybody knows now that there is no more a general imputation. It's more guaranteistic, okay? It is more on the warranty of the imputed subject, and that focus now the form of reasoning is focused on the available evidence. And this concept of availability many times, unfortunately, for subjects that are not dying of having this kind of the sacred profession of medicine, what means that they go to try to hiding all the evidence, starting with a parallel process. because, for example, they prefer to be under imputation for having not carried on some exams, preemptive exams that normally has to occur. Okay? Because they prefer to have this kind of evidence as an omission in the preparation, and not to have the evidence that the result of the exam has been carried out normally. They know what it was, but the after the event occurred, this is a an element that the evidence can support the imputation. In the case of the absence of evidence, we have another kind of imputation, maybe considered light. The outcome of the evidentiary reasoning must have excluded the coexistence of alternative causative factors, and it must be justified and certain in court that the omissive or in any case culpable conduct of the doctor was a necessary condition of the harmful event with high degree of rational credibility or logical probability. That means that we have to find something that not only as a function of exclusion or concomitant, supervenient, or pre-existing causative effects, causative factors, as I told you a few minutes ago, but we must justify, in the sense of go to the imputation, through the nexus of causality, that the omissive or in any case culpable conduct of the doctor is a condition of the harmful event upon which kind of evaluation, rational credibility or logical probability. Please accept this kind of discussion, because we are not, we are, as I told you at the beginning, in case of in the cases of omission, of malpractices generated by omission, we are not discussing about a concrete nexus of causality between the effect and the cause. We have a concrete effect and we have an hypothetical cause that has to enter in our logical and technical process in order to exclude that, in case of this inclusion, the harmful event would never have been took place. Is it okay until now?
Yes, sir. I've raised certain queries.
I'm worried about you, really. Another parallel, yes, Professor.
Today's lecture was very much paradoxical.
Yeah, because we are discussing about something that is not exist.
No, it exists, but it isn't. It cannot be expected that such kind of controversial or contradictory picture at the same time parallelly being shown to whatever the client or the person who is into that kind of malpractice. Because I asked to Pragya also the same question, that if there are malicious motives, and those malicious motives are not acceptable to the one who is an oppressor, who is a committer of crime, so how there would be a no fault or without fault liability then?
Yeah, look, doctor. Even the malicious. If I wish to presume and to find a malicious behavior inside a case that I'm interpreting, I should find something that is much more what normally is required. Because malicious is something that is no more than the concrete intentionality, not the abstract intentionality. The will, the dolus, as we normally call the the subjective element that is enough to start with an imputation is something that the doctor normally know in general, that can derive from a conduct, commissive or omissive. This is what we call the dolus, the will. Okay, malicious is something more.
Okay.
But it is not expected. But it is not expected from the interpreter to demonstrate, because I believe that normal maybe in the United States will be different. I have no notion, but for example, for punitive damages, we will say that malicious behavior, let's say, will be a medical structure, because let's remember that we are not discussing only the liability of us, the single medicine man, but also of medicine facilities, the company running a medical facility. Let's say that in this medical facility has a joint venture with a pharmaceutical factory, for which they are for a treatment that can be provided only under the consent. I'm absolutely discussing of a hypothetical case, hopefully, under the consent of the patient. Okay, and in order to stimulate the consent of the patient, they maliciously subministrate an alternative treatment which is harmful.
Yes, sir. So
In
shall
this
we?
case, we have malicious.
Anybody else?
Yes, we are
Anybody else?
projecting the intentionality of the subject toward the last event that is relevant for law to a more concrete and harmful one. Okay, because but is a very something that may happen also in Europe, in Italy, happened many times. This is a malicious conduct, of course. This going criminal.
Sir, there are certain questions in the chat box, but we will not be taking today or now. You may follow up those questions in your next lecture tomorrow.
Okay, doctor.
You may read those questions. Maybe the framing of language structure may not be right. I think there's one student also raising hand, Yuvraj Shaktawat.
How does transcendent etymology mediate in the solving the ambivalence to underpin causality of liability or the concomitance of retroactive practices? It cannot, because retroactive practices, the evaluation of etiology, and retroactive logical practice, it is not transcendent. It is concrete, because we must absolutely be concrete. We cannot go from the concrete harm suffered by a subject and go back, tracing back it to an abstract form of causation. No, we have to go to a concrete form of causation. We have to impute a concrete conduct to the medicine man that respond to the question if this conduct would have been put in operation in this kind. I'm very general because it's a very large area. Well, in this case, we must be very precise to say that this kind of conduct, medical conduct, let's say a treatment, okay, would have avoid the harm conduct. So etymology in this case, in omission, is etiology is more concrete. Is concrete, okay, in order to be acceptable in a legal trial. How does penal trial can bring suspension of civil appeal liability? Yes, liability, I suppose. Yes, it is automatic. It is automatic. Okay. So when there is many goods that are protected, constitutionally protected, like freedom, I see that the freedom of the medicine man, the honorability, and many others, what is considered as a low-level liability, like the patrimonial liability that terminates in compensation, is say the step. So it is a second aspect. All the many norms, but chiefly one, Article 180 from penal code in Italy, let's say, automatically bring the evidence from the criminal process to civil process.
Right, sir. So shall we now
The last one is paradoxical in relating to configuration label to explore omission or commission. We need one more carry forward lecture with cases of evidence. With great pleasure, it's only matter of only matter of an appointment, and no problem for me, Just I wish to focus these. Just I wish to focus these. Why? We are in a just to close the discussion and to move to other questions if there are. We are in an era where also, there are vast movements of subjects who try to exercise their right of intervention in this field. We had this an experience with the movement, Novax movements, in the cases of the vaccine for COVID. Yes. So the case of omission, the case of the doctor who is under judgment for what he had done or for what he had not done, the case of omission is a case of the frontier of the civil liability in matter of malpractice.
Right.
So I will say that it is taking also 50% of all the cases in malpractices today. Okay, I'm at your disposal for any question.
Sir, today we are very late.
Okay, I apologize.
No, you need not to apologize, because today we had 3 speakers and all were very good. They took time in their own discourses, and so you got delayed. Most likely you should have started by 7:45 p.m. and I gave you chance at 8:15.
Okay.
So I think I should say sorry.
No, on the contrary. Thank you very much, doctor.
Bye, sir.
Bye-bye. Bye-bye, everybody. Bye.
Bye.